of Florida Supreme Court. Please be seated.
Good morning and welcome to the Florida Supreme Court. Our first case today is Boatman versus State of Florida, number 2022-1547.
Thank you, Chief Justice Muniz. Your Honors, good morning. My name is Attorney David Jaffe, and I have the pleasure of representing the appellant, Mr. Leo Boatman, in this direct review from his conviction at the trial court in Bradford County, the 8th Judicial Circuit. Mr. Boatman was convicted of first-degree murder and was sentenced to death by the trial judge. Mr. Boatman's dystopian life began when he was born in a mental institution to his mother, who was also in the mental institution. His father was also in that mental institution. Mr. Boatman was there for approximately 3 years, according to my review of the records. When he got out, he was taken from his mother by DCF at some point, was given to his grandmother. His grandmother gave up parental rights. And like many individuals that end up serving in the Florida State Prison system, he went to DCF, and he finds himself here today. On November 4th, 2019, the state of Florida charged Mr. Boatman in a 2-count true bill, charging Mr. Boatman and Mr. Wells with premeditated murder.
How old was he when he was charged?
How old was
he when he was indicted?
In this particular case, I'm not certain of his exact age, but I think Mr. Boatman was still relatively young. Mr. Boatman had a history of prior murders, Justice Labarga. He had, unfortunately, had murdered 2 individuals in the Ocala National Forest, 2 FSU students, had attempted to murder someone in the Florida State Prison, was caught in the act, and I believe had murdered someone else previously as well in the Florida State Prison. So unfortunately for Mr. Boatman, he has a history of committing murders as well. And what happened in this particular case is Mr. Boatman, along with another individual, Mr. Wells, planned and committed a murder of an individual in the day room in the Florida State Prison. While this act was occurring, Florida State Prison officials attempted to enter the room, and they claimed they were not able to enter the room because Mr. Boatman was somehow blocking the door. Find that a bit odd because I don't know how one individual could just block a door. Anyway, that event took approximately 12 minutes, and the individual was dead once the Florida State Prison officials were able to enter the room. They tried to disperse a chemical agent, and eventually once they went in, he was dead. Mr. Boatman and the other...
Didn't they try to disperse the chemical agent before they got into the room?
That's my understanding. Okay. There was a crack in the door, and they attempted to disperse the chemical agent, and they were told by their supervisor to let, I believe it was a DART team, which is designed and they're better equipped and armed to deal with violent acts in the prison system. Mr. Boatman was interviewed.
Well, the officers who aren't equipped to do that couldn't be expected to go up against somebody with a shank.
No, and I'm not suggesting that.
That's kind of what you were suggesting.
I'm not suggesting that at all. I'm just saying that when the event was occurring, it took approximately 12 minutes, and while the individual was being stabbed in his eyes, while he was being choked, and while he had this metal object in his neck and was being stomped, it eventually was stomped so that the metal object went through his neck, and that may have eventually killed him as well. At some point during this case, Mr. Boatman's trial counsel filed a motion to determine competency in this particular case. Mr. Boatman had a history of several suicide attempts during his life. He had been admitted to Shands Teaching Hospital as well in Gainesville, Florida for treatment. Again, he was born in a mental hospital. I don't know that it gets any worse than that, to a mother who was also in a mental hospital. He was neglected by everyone who raised him, essentially. Dr. Weidner noted that Mr. Boatman met the diagnostic criteria for competency, but yet still said he was not competent because he did not have a rational or an adequate understanding of the proceedings, and he is not able to make a free and rational decision as it relates to his decision to plea or go forward with trial.
I think the problem is that Dr. Weidner's findings seem to always start out with he had an adequate appreciation for whatever. And he used the word adequate over and over again. But he did say that he had an adequate capacity to testify relevantly in court if he chose to, an adequate capacity to manifest appropriate courtroom behavior, and an adequate capacity to disclose his lawyer's facts pertinent to the case. It just seems like, he was just there, but yet adequate capacity to basically understand the proceedings and proceed to trial. So where do you go from he's adequate, he's average, to not being competent?
Well, Justice Labarga, I think, because this is a death penalty case and because, you have a mental health professional saying, he's adequate, but yet he's still not competent because he doesn't have a rational understanding. And because the trial judge has such great discretion, and there's case law that says that, the trial judge can, on his or her own, appoint another doctor to evaluate the individual to determine, competency, that would it not have been better to appoint another doctor? Now, could not have the attorney representing Mr. Boatman also have asked another doctor to evaluate for competency? Now, granted, there were doctors involved in mitigation in this case, and obviously mitigation, coincides with competency. But I think for our purposes, we're focused here on competency. It would have been a better practice for either the trial court or the trial lawyer to have asked for another doctor to have been appointed. And that's why, even on that issue alone, I'm asking the court to reverse and remand this case back to the trial court so that doctors can be appointed, so that Mr. Boatman can be evaluated, properly evaluated. Because at that point, Mr. Boatman could theoretically have been sent to the Florida State Hospital for further evaluation. We could have stayed for 3 months, 6 months, 9 months, a year, and been seen over a longer period of time, so that this issue may in fact be a non-issue, where he could have been medicated or not medicated, where they could have made a further determination as to whether or not he really was competent.
So I think you started your answer with the fact that since the state is seeking the death penalty, there should have been a higher calling here.
Yes.
And perhaps that, so you adhere to the theory that death is different, and therefore there should be, more stringent requirements in these cases as far as making sure that he is competent and not competent.
That's an interesting statement, and I thought a lot about that, because I think sometimes the statement "death is different" is overused, and I think it can be overused to the point where it's dangerous to overuse that, and I think it could get to the point where it's so dangerous it could be used against the defense or against an appellant. I would think that in every case where a doctor were to come in and say, this person meets the minimum criteria, but they're not competent, I think I, as a jurist, would say,
of course,
well,
she wasn't consistent about that. The expert was all over the place. When she's asked the specific question of whether he was incompetent to make this decision, she says, no. So it's just, this is not a case where we have an unequivocal expert testimony, and of course, how that gets dealt with, it might be different, but that's not the case we've got here, is it? The expert's all over the place. She wants to do, pretty clear to me from looking at what she said, that she wants to say things that are going to help the guy, but she's kind of hemmed in by the realities of what he said and done. What am I missing?
That's correct, Justice Kennedy. And I think at that point, because she is maybe waffling or being wishy-washy or not being maybe direct, I think at that point the court can make a determination. I either accept what you're saying, I don't accept what you're saying, and I appoint another doctor or two doctors to evaluate Mr. Boatman, because I need something more concrete, more solid to rely upon, because I can't rely upon.
Well, but he's got his own eyes and ears to rely on. He's been observing Mr. Boatman and listening to him, and this is people like Mr. Boatman are in a very difficult position. We all understand that. I think Mr. Boatman's trying to exercise what agency he has, and he's made choices about what he wants to do here, but it's just hard to see how there's anything that would point toward incompetence here. You may disagree with it. It might be a decision that you wouldn't make if you were in his shoes, but that's not a basis for concluding that he's incompetent.
You raise a good point, because I think what Mr. Boatman may ultimately be trying to do is actually get himself to death row because he wants to get out of close management, because he's grating at the fact that he's under close management. He doesn't want to be in close management anymore. He's done all these things in the state prison system to try and get in the good graces.
Well, like commit multiple murders? I mean, it's like...
I'm sorry, go ahead.
I'm sorry.
Is that rational? Do rational people do that? No. I don't think that that's cold and calculated. I think that leads to a certain level of mental illness. Something is wrong here, I think.
That's not the test before us.
I'm sorry.
It's not the test. We don't say that, anyone who has a mental illness or has some degree of trouble is incompetent. To the contrary, we won't revisit the question unless no reasonable person would take the view adopted by the trial court. And so it seems like maybe we should focus on, obviously it has to be your position that no reasonable person would have done what the trial court did here in light of the testimony of the expert and the judge's own observations of Mr. Boatman. So do you want to make that argument? Because I candidly don't see it, but you're here arguing for him, so I feel like you need to sort of cut to the chase and tell us whether no reasonable person would have found him competent.
I don't know that no reasonable person would have found him competent or not competent, because I don't think from this record we can make that determination. And what Justice Kennedy had mentioned, that the trial judge is there observing Mr. Boatman. We're not psychic. We can't get into Mr. Boatman's head and really see what's going on as the wheels turn inside Mr. Boatman's head. He may need a neuropsych evaluation to really determine, and then maybe further, he may need a CAT scan or further examination to really determine, does he have brain damage? Is there something more going on to really determine that level of competency? Is he competent? So in answer to your question, I'm not a licensed psychologist. I'm not a licensed psychiatrist. I can't just look at someone and say, you're competent, you're not competent, spend an hour with you. I think there needs to be several days spent with the person, several days of testing, which is what a neuropsychologist can do. And I think the standard under Florida law for competency is extremely low. And because of what Justice Kennedy was saying about this doctor being wishy-washy and all over the place, I'm asking the court to reverse and remand this case back to the trial court for a determination whether or not Mr. Boatman was competent or not. Most respectfully, I don't think it's enough to say, well, the trial judge is able to watch this person and say, well, I think you're okay. I mean, I don't think that's enough. I think we need, licensed psychologists, doctors to say that for us. I think that's why we as practitioners rely upon them in mitigation. That's why we rely upon them in the competency phase. And Justice Labarga, I think you had asked me a question, and then I got diverted to another question. I'm not sure if I answered.
No, you answered it. One thing that strikes me is there were 4 aggravators in this case, and they were all weighty aggravators.
Right.
The first one was previously convicted of felony and under the sentence of imprisonment, and the judge gave it very great weight. The second one, previously convicted of another capital felony, very great weight. And there was HAC, very great weight. But then there was CCD, which was the main one here, because these guys, Ham and Wells, planned this. They planned to kill someone else, and then they changed their mind about this guy. Well planned. CCD, only great weight. So what happened there? Is that somehow connected to the mental issue that the judge only gave him great weight as opposed to very great weight?
We don't know, because it's not, that hasn't been, it's not drawn out, it's not brought out, it's not analyzed from the record below. We can only surmise from that, and one could surmise from that issue, and from an intellectual standpoint, one could make that connection, and therefore even draw it further and say, because of that, the case needs to be remanded, and that Mr. Boatman needs to be evaluated for competency because of that issue. Okay, thank you. And I think, this court has held in Sweet in 2002, in Rutherford in 1998, and in Bruno in 2001, Justice Anstead, that mental health evaluations are fundamental in defending against the death penalty. So, when we raise the issue of death is different, I think somehow that may play into account there. Now, when Mr. Boatman essentially waived his right to a jury in the penalty phase, I think that also ties in with the issue of competency. Mr. Boatman, on his own volition, filed his own pro se motion waiving his right to have a jury hear the penalty phase. Now, traditionally, when pro se litigants or when litigants are represented by counsel and they file something with the court, many times it's kicked out, it's rejected, it's sent back, and the clerk or the judge will say, you're represented by a lawyer. We won't accept this. I'm unclear as to why this trial judge allowed this to happen in a case of such magnitude, especially when there was an issue as to whether Mr. Boatman really could understand what he was doing here. I mean, by doing this, based upon what this trial judge had done previously, basically what Mr. Boatman was doing was almost guaranteeing himself a death penalty sentence.
Just from hearing what you say here, you'd think that the judge just got what Mr. Boatman asked for and said, okay. That's not what happened. I mean, wasn't there an extensive colloquy?
With Mr. Boatman, you mean?
Yes.
Well, yes, Justice Kennedy, there was an extensive colloquy, but our position is that Mr. Boatman was not competent and that he had a surreptitious desire to get to Union CI, to get to death row. And he was not rational. And
well, I think to the contrary, that reflects a degree of rationality. He had a goal, and he understood that committing the murder would get him where he wanted to be. That sounds pretty connected to reality, don't you think? Sounds like motive.
It's a double-edged sword, right?
Yeah.
Right. And as lawyers, we can argue both sides of that double-edged sword, right? And my perspective would be that for someone to do that, it's just not rational.
Isn't it more, didn't Dr. Warner ultimately characterize it as a matter of judgment, though, rather than rationality? And why is that not an accurate characterization of that decision?
In what sense? I'm sorry.
It's just she questions his judgment rather than his competency. Those are kind of distinct concepts, right?
Right. And are you saying that, are you tying that in with Dr. Warner's kind of wishy-washiness about competency?
Well, I'm asking, you seem to say that it's almost a bright line rule that if somebody wants to get death row, they must be incompetent. And when we're looking at a record to determine whether, what the legal arguments are and what the evidence supports, we see her characterize that more as a judgment issue rather than a competency issue.
Well, I think in this case, yes, we can take that into account as well as competency. I think we could look at both. I think here we can look at Mr. Boatman's judgment or lack thereof. And I think we have to take into account his entire life experience from the time he was born in a mental institution all the way up to the point where he's, undergoing, the questioning or the colloquy by the trial judge as to whether or not, he's waiving his right to have the penalty phase heard by a jury or by a trial judge. And I don't know that he's ever been colloquied as to that issue before. This may have been the first time he was colloquied as to whether or not, you want a jury to make a determination or a judge to make a determination as to your fate, essentially. And I would think that any good trial lawyer would want a jury to make that decision and not a judge. And I don't think that a rational person...
But again, this is not about wisdom.
I'm sorry.
It might not be a smart, but you're focusing on what would be wise as opposed to what demonstrates incompetence. And those are different things. I mean, that's the point that's being made. This is a question, it's not about judgment or wisdom, it's about competence.
That's correct, Justice Kennedy, and I think it goes back to what you said about the doctor's wishy-washy, I use the term wishy-washiness, but her somewhat lack of commitment in her statements about competency, or what you termed that she was, trying to fit maybe a round peg at a square hole.
What evidence can you point to in the record that Mr. Boatman didn't understand that he was in a trial, in a judicial proceeding?
Justice Curiel, I don't think there's anything in the record that says that, Mr. Boatman thought that he was, on a beach getting a suntan. Okay. I mean, I think he knew.
And what evidence can you point to in the record that Mr.
And I don't say that to be flippant.
No, I get it.
Right.
And what evidence can you point to in the record that Mr. Boatman was incapable of assisting counsel in his defense? That's a test.
Right. I don't know that there's enough in the record to say assisting counsel, other than in his writing to the court, he did say that in his motion to disqualify the trial judge, he did say essentially he was happy with his trial lawyers, and that he was okay with them getting the continuances and getting adequate time to be able to defend him. But that he now was calling into question the judge being able to be fair and impartial, because he felt that the judge at one of the status conferences was saying that his trial lawyers were lying to the court at that point, because they were asking for continuances. The lawyers were representing that they were setting depositions, but yet the depositions weren't being taken. So the court, of course, the court has to move its calendar, said, we're going to move forward with this. We're not just going to continue this, ad infinitum. Does that answer your question?
I guess it's your best effort at answering my question. Yeah.
It is my best effort. Thank you. And Justice Sasso, I was answering your question, and
I think you answered it. Thank you.
Okay, thank you. Also on August 6, 2021, Mr. Boatman filed a motion to disqualify the trial judge, and 4 days later it was denied as legally insufficient. In Lewis v. State, the Florida First District Court stated that a motion to disqualify a trial judge is legally sufficient when the alleged facts would place a reasonably prudent person in fear of not receiving a fair and impartial trial. And I think in this particular case, Mr. Boatman honestly felt that he would not receive a fair and impartial trial, and I see that I'm running into my rebuttal time. So,
Thank you.
If there are no more questions, I'll sit down. Thank you.
Thank you, Mr. Chief Justice, and may it please the Court. I'm Assistant Attorney General Rick Buckwalter. I represent the appellee in this case, the state of Florida. I intend to limit my responses to those arguments made by opposing counsel, unless, of course, the Court has other questions.
Just my question, I'm just curious, of the four aggravators here, the weightiest, I think, was obviously HAC. The victim obviously went through, suffered, tortured. But CCP was it. I mean, they planned this, and yet only great weight, I say only, it's great weight is a lot of weight, but very great weight for the other ones, and just great weight for CCP. I don't get it.
I don't know why the trial court found there was great weight versus that versus very great weight for the others. There's clearly strong evidence of CCP. Apparently the court didn't weigh that as heavily as he did the other aggravators. That's the only response I can really provide.
I'm just wondering if it's CCP deals with the what's going on in the mind of the defendant, as opposed to the HAC that deals with the victim. So I'm just wondering if it has any connection to the competency. Maybe the judge decided that perhaps it was not as competent as it should be, or something like that. Anything like that in the record?
There's nothing in the record that I'm aware of that would suggest that at all. It just seems to be, and again, I'm surmising at this point, just seems to be that he doesn't provide as much weight for that particular aggravator. I mean, clearly there's great evidence of the planning. There's the post-Miranda admissions, the obtaining the weapons.
Yeah, great weight is something you don't want to have if you're a defendant, but the other ones were very great weight. Just wondering what the reason was.
But there's nothing in the record that I can think of that provides any indication as to why he weighed the other, he didn't weigh that aggravator as much as the other aggravators. With regard to the competency issue, first I want to point something out, that the issue that was raised in the initial brief in this case on competency has to do with the court's decision, and I want to mention that only because during argument there was some talk about the fact that maybe the attorney should have had another doctor appointed or something along those lines. That issue was never raised as to whether or not the lawyers in this case were somehow ineffective for doing that. I just want to point out to the court, what we're dealing with here is whether or not the court abuses discretion, and when the court found that Mr. Boatman was competent to continue in his trial. And clearly, I think that the record supports that. Certainly, I don't think we could say that no reasonable judge would have found that he was competent to proceed, that no unreasonable judge would have found he was competent to proceed. We have the Dr. Werner's testimony where, as been indicated, she indicated he had an adequate understanding of the proceedings against him. He had an adequate ability to participate in his own defense. That's the test. And in fact, in this case, the doctor supports the finding of competency, even though she concludes otherwise in her end. As the trial court mentioned, I think rather aptly, the trial court said in summarizing her testimony, basically, she says it walks like a duck, it quacks like a duck, but I'm going to call it a chicken. Well, no, it's not a chicken, it's a duck. If he has the adequate understanding of the proceedings, he's able to rationally assist his attorney, he's competent. So the court certainly did not abuse its discretion in finding that. In fact, the record supports the court's finding because there is no outward manifestation by Mr. Boatman during his trial regarding that would give any indication of incompetency. In fact, Mr. Boatman in this case testified in his own behalf in a very rational manner. There's very little question, I think, that the court correctly determined that he was incompetent, certainly did not abuse its discretion in doing so. With regard to the waiver of the right to his death penalty jury, it's a very similar issue, as the courts recognize. In this case, Dr. Werner was coming to testify in the penalty phase, so the court asked Dr. Werner to take some time to go back and speak with Mr. Boatman for a period of time, and then come out and talk to the judge about the waiver. And at that point, the court had already made a determination of competency. So there's a presumption at that point that he is competent. And there's nothing in the record to indicate at that point that he's incompetent. So, as I believe was Justice Sasso pointed out, that she really is questioning his judgment about whether or not that's what he should be doing. That's not the test. Again, the test of competency has to do with his ability to understand the proceedings and his ability to assist his attorney. And there's no evidence in this case to the contrary. The last thing I just want to briefly touch upon is the disqualification motion on the trial judge. The standard review for this court, I understand, is a de novo review, but the test is whether a reasonable person would have a fear of his inability to get a fair trial. And I don't think there were any comments made by the trial court in this case that would indicate to a reasonable person that he couldn't get a fair trial. The court clearly had some concerns about moving the case along. He had spoken previously at prior hearings about trying to get the case set for trial, and the fact that on this hearing date, was when they were going to have the pretrial conference and set it for trial. Up to that point, there had been indication about depositions being taken, the scheduling of those depositions, and the court was questioning why things that he had been told would be calendared weren't taken care of, and why it is that they weren't prepared to go to trial. They had made a request for a continuance so that they could so that they could go to the death penalty seminar. And the judge denied the continuance, and shortly thereafter, the motion was filed. It seems that the basis really is that they were trying to obtain a continuance. I believe that's what the court is indicating its concern about, but the court made no statement that would give any reasonable person the fear of not being able to get a fair trial. Unless the court has any other questions, I'll conclude by requesting that this court affirm the conviction, the sentence of Mr. Boatman. Thank you.
Thank you very much.
In Muhammad v. State, the Florida Supreme Court stated in 2001, this court found that a trial judge may still require an advisory jury recommendation as to the penalty phase, citing State v. Carr, C-A-R-R, a 1976 decision by the Florida Supreme Court. So what this case is essentially saying is that during the penalty phase is that a trial judge can accept a waiver from a defendant in a death penalty case and can also say, fine, sir, I'll accept your waiver, but at the same time, in an abundance of caution, I'm going to let the jury remain here, make a decision, so that I can make sure that the decision that is being
But there's nothing that says the judge has to do that.
No, of course not, Justice Kennedy. Of course not.
So what does that have to do with anything?
Well, that's why we're here. We should just go fishing.
We're here because the judge failed to do something that he wasn't required to do?
This is Florida Supreme Court precedent, and what I'm saying is that it would have been better practice, especially in a case like this, to avoid these issues, most respectfully, to.
Did you argue this specifically?
I'm sorry?
Did you argue this specifically?
In the brief below?
In the brief, yeah. The brief here.
No, I believe this is something that I found as I was doing additional research for the oral argument, Your Honor.
Okay, so you should move on to something else. You should just be limiting yourself to responding
very
to what
good.
he talked about.
I have nothing further, Justice Munoz. Thank you so much. Thank you for the panel. Thank you for your time. Thank you. Thank you, Justice Kennedy. Thank you.
Thank you. We'll take a 10-minute break.
All rise.